Chapter 1. Introduction. The Importance of Law and Order. The legal system forms the basis of every organized society. It is the invisible framework on which political, economic, and social structures rest. Without law and order, human communities would be at the mercy of chaos, arbitrariness, and conflict. From the earliest forms of human coexistence, humans have recognized that rules are necessary to structure coexistence, protect property, resolve conflicts, and regulate power relations. This insight that behavior is not exclusively subject to individual freedom but must be regulated in a social framework laid the foundation for the emergence of legal systems. Law is not only an instrument of control or punishment, but also an expression of social values, norms, and morals that develop and change over centuries. Law has the function of ordering actions and resolving conflicts before they escalate. In early communities, in tribal societies, or in the first settlements, law was often closely linked to traditions, religious ideas, and oral rules. It was less about abstract principles than about living together directly, about protecting the family, property, and community. With the increasing complexity of societies, the demands on the law also grew. Trade relations, political structures, property relations, and social differentiation necessitated a differentiated and binding regulation that went beyond the simple tribal tradition. This development led to the codification of norms, the emergence of courts, and the training of legal professions specialized in the application and interpretation of the law. A central feature of the law is its ability to make norms binding. Unlike moral ideas or social customs, law is based on sanctions and enforceable rules. The punishment of violations by state authority or other institutions ensures that the law does not only exist theoretically, but has a practical influence on people's behavior. The legitimation of the law is closely linked to its acceptance by the community. When law is perceived as arbitrary or unjust, it loses its effectiveness and social tensions arise. Therefore, every legal system also reflects the values, ideals, and power relations of the society in which it exists. The history of the legal system shows that law is never static. It is constantly evolving, adapting to changes in society and responding to new challenges. From the first oral norms to complex codified collections of laws, a continuous process of refinement and adaptation can be seen. Each epoch produced its own questions, its own conflicts, and its own solutions, which in turn formed the basis for later developments. Law is not only a mirror of society, but also an instrument of design. Laws can be used to pursue political goals, promote social justice, or control economic activities. Legal systems are thus not only reactive, but also proactive mechanisms of the social order. Another essential element of law is its universal dimension. Although law is specific to each society, there are basic principles that are recognizable in almost all cultures. These include the regulation of property, the protection of life and health, the organization of the community, the definition of responsibilities, and the possibility of dispute resolution. These principles form the basis for the emergence of codified legal systems and international norms that claim validity beyond local and national borders. With increasing globalization and the interconnectedness of states and societies, this universal dimension of law is becoming increasingly important as national legal systems are increasingly integrated into international contexts. The development of law is closely linked to the emergence of institutions. Courts, parliaments, administrative units, and legal professions are created to administer, enforce, and interpret the law. These institutions ensure that law does not only exist as an abstract norm, but is practically applicable. At the same time, they reflect social hierarchies, power structures, and historical developments. The organization of the administration of justice, the independence of the judiciary, and the competence of legal authorities are decisive for whether the law is effective, fair, and stable. Institutions are thus an indispensable part of the legal system as they ensure the mechanisms of implementation and control. In addition to its functional meaning, law also has a symbolic dimension. It embodies the idea of justice, fairness, and order. Social morality is codified and made visible through the law. Citizens can claim their rights, recognize their duties, and understand social norms. The symbolic function of law strengthens trust in society, in the state, and in the institutions that enforce the law. Without this symbolic acceptance, law loses its legitimacy, regardless of its formal bindingness. The legal system is also closely linked to the political order. States define law, enact laws, and enforce them, thereby acquiring authority and legitimacy. At the same time, legal norms can influence the distribution of power in societies. They can entrench or reduce social inequalities, promote or inhibit innovation, and secure or challenge political decisions. History shows that law is never neutral, but always embedded in political, economic, and social structures. The meaning of law also extends to the individual level. Every person lives within a framework of rights and duties that guides behavior, protects protection, and regulates conflicts. This tension between freedom and obligation, between individual action and social order, is a central feature of all legal systems. Those who understand the law recognize the mechanisms that order coexistence, the possibilities it offers, and the limits it sets. The introduction to the history of the legal system therefore shows that law is much more than a collection of laws. It is a lively, dynamic process that reflects social values, structures institutions, resolves conflicts, and embeds individual freedom in a social framework. It is the result of historical developments, philosophical considerations, and practical necessities. Without law, the organization of communities and states would be unthinkable. Without law, social cooperation would reach its limits. The legal system is thus a key to understanding human civilization, a mirror of the past, and a tool to shape the future.
Chapter 2: Early Legal Systems, From Tribal Norms to First Codifications. The history of the legal system begins long before the great empires, codes, and jurists, in the earliest communities of humanity, where the idea of law and order was still closely linked to traditions, religion, and the immediate need to live together. In these prehistoric societies, there was no written law, no courts in the modern sense, and no abstract principles of justice, but rules that ensure the survival, cooperation, and stability of the group. Law here was directly tied to daily life, and norms developed organically, often through repeated experiences, rituals, or the authority of the elders. Any action that upset the balance of the community or endangered resources was sanctioned, not necessarily by systematic punishment, but by social ostracism, deprivation of status, or exclusion from the group. Early humans intuitively understood that rules were necessary to avoid conflict, promote cooperation, and ensure the survival of the group. The development of legal systems was closely linked to sedentary life. As people began to cultivate crops, establish permanent settlements, and own property in the form of land, livestock, or supplies, new needs for binding rules emerged. Property had to be protected, disputes over land and resources had to be settled, and responsibilities clearly distributed. In these early societies, the law often took the form of oral norms, taboos, and customs that were passed down through generations. The elders or special authority figures had the task of preserving these norms, applying them in conflict situations, and obligating the community to observe the rules. The first forms of law were thus not abstract, but concrete, socially embedded, and closely linked to the power structure of the community. A defining feature of early legal systems was the combination of law and religion. Many of the oldest known societies considered law and morality to be inseparable. Violations of social norms were often seen not only as a disrespect for the community, but as a violation of divine order. Rituals, taboos, and religious commandments there formed a core component of early law. Religion conveyed not only sanctions, but also legitimacy. Those who followed the rules acted in accordance with the divine. Those who broke it risked not only social sanctions, but also the wrath of the gods. This combination of law and religion was to form the basis of many later legal traditions, especially in cultures such as Mesopotamia, Egypt, or Israel, where religious and secular authority were often closely intertwined. The first written laws were created mainly in regions where complex societies, trade, and centralized power structures needed clear regulation. Mesopotamia is considered a central starting point of this development. Here, not only the social structures became more complex, but also the economic relations. Trade contracts, property rights, and criminal provisions had to be binding and comprehensible. The famous collection of laws of King Hammurabi of Babylon, written around 1750 BC, is an impressive example of this early codification. It combined the traditional customs, the political guidelines of the rulers, and the social ideas of the community in a clearly structured code. Hammurabi's tablets of the law regulated not only property and inheritance, but also criminal law, trade, and social duties. They show how legal systems have become increasingly abstract, written, and centralized, but without losing the connection to social reality. At the same time, early legal norms also developed in other regions. In Egypt, law and administration were closely linked to the rule of the pharaohs. The law served not only to maintain order, but also to enforce political power. Egyptian legal practice relied heavily on written documents, such as administrative regulations, contracts, or deeds, while oral traditions continued to have a significant influence. Similar developments can be observed in the Indus culture, whose characters have not yet been fully deciphered, but whose urban planning, water management, and trade relations point to highly organized regulations. Here, law was an instrument that regulated everyday activities, minimized conflicts, and stabilized the community. Traces of normative regulation can also be detected in the early societies of Europe and Africa. Tribal societies developed complex codes for succession, marriage, punishment, and social roles. Conflict resolution often relied on arbitration, conducted by recognized members of the community. Such procedures made it possible to restore social harmony before conflicts escalated. Even though these norms were not written down, they formed the basis of later legal systems. They make it clear that law is a universal human need that develops independently of culture, time, and space. The early legal systems also show that law always exists in a field of tension between individual interests and collective needs. On the one hand, there is the need for personal freedom and property, and on the other, the need to ensure the survival and stability of the community. This tension leads to compromises, regulations, and institutions that both protect individual rights and ensure the well-being of the community. The transformation from oral law to the first codifications marks a decisive turning point in the history of the legal system. It allowed for greater predictability, more binding regulation, and the possibility of transferring legal norms across generations and spaces. At the same time, it led to a professionalization of the law, as specialized actors such as judges, clerks, or legal scholars were required to monitor compliance with the rules and ensure their application. Codification marked the beginning of the systematic development of legal principles that later became the basis of the world's great legal traditions. The early legal systems thus show that law is a product of both practical necessity and cultural values. It is the result of human experience, social organization, and political formation. Law does not arise in a vacuum, but in response to concrete challenges that affect the survival, cooperation, and order of a community. The study of these early forms not only offers insights into the social structures of the past, but lays the foundation for understanding the complex, codified, and institutionally anchored legal systems that would emerge thousands years later.
Chapter 3: Mesopotamia and the Law of Hammurabi. The history of the legal system reached a decisive stage in Mesopotamia, in which the first complete codes were formed and the role of the law in state and society was redefined. Mesopotamia, the fertile land between the Euphrates and the Tigris, has been a center of human civilization since early times, characterized by complex city-states, intensive trade, agriculture, and social hierarchies. Not only did an impressive culture emerge in this region, but also the first written collection of laws, which is still considered a milestone in the development of law. The Law of King Hammurabi of Babylon, written around 1750 BC. Hammurabi, the sixth king of the first Babylonian dynasty, ruled over an empire consisting of numerous city-states, whose relations with each other were often conflictual. In this context, the need for a uniform law was both political and social. By codifying his laws, Hammurabi not only wanted to settle disputes, but also to centralize and legitimize his power. The law, carved in stone and publicly established, represented a binding standard for all citizens and was intended to secure the justice willed by the gods. The central message of the code was that order and law do not arise by chance, but are determined by the ruler in accordance with divine instruction. Hammurabi's law is remarkable in many ways, as it encompasses a variety of social, economic, and legal regulations. It covers property rights, contract law, inheritance law, criminal law, family law, labor law, and economic transactions. The structure of the laws follows a principle of causality and retribution that later became known as the lex talionis, an eye for an eye, a tooth for a tooth. This form of punishment was intended to strike a balance between the offense and the punishment, and at the same time provide a clear deterrent. At the same time, the code shows a differentiated view of status and social hierarchy, as the punishments vary depending on the social position of the perpetrator or victim. This principle may seem unjust today, but it shows the early recognition of social differentiation and the integration of these differences into the legal system. Another central feature of the law is its combination of law and religion. Hammurabi begins his codex with a proclamation that he establishes justice and protects the oppressed, as the gods would have commanded. The law is thus understood not only as an instrument of worldly order, but also as an expression of divine purpose. The idea that law descends from heaven shapes the later development of legal systems in many cultures, giving law an authority that goes beyond the mere power of the ruler. This shows how law in Mesopotamia was not thought of in isolation, but as an integral part of religion, politics, and society. The codification itself was revolutionary, as it brought the law into a permanent, verifiable form for the first time. While earlier norms were mainly handed down orally, Hammurabi's legal text provided a written reference that was publicly available. This development allowed for greater predictability, as citizens, judges, and administration could fall back on a fixed set of rules. It also contributed to the professionalization of the law, as specialized clerks, judges, and administrative officials were needed to monitor compliance, issue judgments, and resolve disputes. The practical impact of the code on everyday life was enormous. Property disputes were clearly regulated, contracts could be fixed in writing, and family relationships were structured by defined duties and rights. Economic relationships, such as buying, selling, granting loans, or employment relationships, also found binding legal framework conditions for the first time. The law thus created a stable social and economic framework that supported the emergence of more complex urban societies. The introduction of written law also facilitated administration, as it made it easier for central authorities to enforce and monitor them, and conflicts could be resolved on the basis of clear norms. At the same time, the laws show that law has always been an instrument of power in Mesopotamia. The penalties for offenses were often drastic, and the law served to maintain social order and secure the position of the ruling elite. For example, there were special regulations for slaves, women, or members of lower social classes who enjoyed less protection or received harsher punishments. This shows that law functioned both as a means of protection and as an instrument of control. It was never neutral, but always embedded in a complex web of power, religion, and society. The codification itself was revolutionary as it brought the law into a permanent, verifiable form for the first time. While earlier norms were mainly handed down orally, Hammurabi's legal text provided a written reference that was publicly available. This development allowed for greater predictability, as citizens, judges, and administration could fall back on a fixed set of rules. It also contributed to the professionalization of the law, as specialized clerks, judges, and administrative officials were needed to monitor compliance, issue judgments, and resolve disputes. The practical impact of the code on everyday life was enormous. Property disputes were clearly regulated, contracts could be fixed in writing, and family relationships were structured by defined duties and rights. Economic relationships, such as buying, selling, granting loans, or employment relationships, also found binding legal framework conditions for the first time. The law thus created a stable social and economic framework that supported the emergence of more complex urban societies. The introduction of written law also facilitated administration, as it made it easier for central authorities to enforce and monitor them, and conflicts could be resolved on the basis of clear norms. At the same time, the law shows that law has always been an instrument of power in Mesopotamia. The penalties for offenses were often drastic, and the law served to maintain social order and secure the position of the ruling elite. For example, there were special regulations for slaves, women, or members of lower social classes who enjoyed less protection or received harsher punishments. This shows that law functioned both as a means of protection and as an instrument of control. It was never neutral, but always embedded in a complex web of power, religion, and social hierarchy. The structure and philosophy of Hammurabi's law had far-reaching consequences for the development of law in other regions and epochs. The idea of written codification, the causality between crime and punishment, the connection between law and religion, and differentiation according to social status formed a basis on which later legal systems could build. Traces of these principles can be found in the Hebrew Bible, Roman law, and many medieval codifications. Hammurabi's code shows that law is always also an expression of cultural and political contexts, that it reflects historical change and, at the same time, has a normative effect. The Mesopotamia of the Hammurabi period illustrates how law becomes a central organizational instrument in a complex society. It not only regulates actions, but structures power, influences morality, defines justice, and shapes the social order. The written fixation of law represents an important step, as it replaces the tradition of oral customary law and makes law a stable, verifiable, and binding system. At the same time, however, aspects of the social and religious context remain present that show that law never exists in isolation, but is always embedded in the fabric of the community. Hammurabi's law is therefore considered a milestone in the development of the legal system, not only because of its codification, but also because of its comprehensive regulation of human relations, its combination of law, power, and religion, and its function as a factor of social stability. It marks the transition from organically grown norms to systematically recorded, written rules that were to form the basis for later legal systems and modern legal systems. The principles contained in this code continue to have an impact today, both as a historical source and as an example of the early systematic regulation of human societies by law.
Chapter 4: Ancient Egypt and the Development of Law and Administration. Ancient Egypt, one of the longest-lived civilizations in human history, offers a fascinating example of how law and administration were intertwined to stabilize a highly organized society. Egyptian culture was characterized by continuity, hierarchy, and a strong central state that maintained similar structures for thousands of years. While Mesopotamia produced the first comprehensive legal codes with Hammurabi, Egypt was characterized by a legal system that was more oriented towards administration, tradition, and divine order. Egyptian society understood law not as an isolated collection of rules, but as an expression of Ma'at, a concept that combined order, justice, truth, and cosmic harmony. Ma'at was both a moral principle and a legal idea that guided the actions of pharaoh, officials, and citizens alike.
In Egypt, the pharaoh was the central authority of the legal system. He was considered the representative of the gods on earth, responsible for preserving Ma'at and ensuring harmony between heaven, earth, and humans. In this context, law was inseparably linked to religion. The pharaoh could enact laws, decide contentious cases, and issue administrative regulations, but his power was legitimized by tradition and religious consensus. Unlike in Mesopotamia, there were no codified, generally accessible legal texts such as the Codex Hammurabi, but the law was nevertheless present and structured, as it was documented in the form of administrative decrees, deeds, treaties, and court rulings. In Egypt, the administration played a central role in the implementation and safeguarding of the law. Officials at all levels oversaw taxes, land ownership, trade activities, work orders, and litigation. Particularly important was the system of the nomarchs, who exercised local power in the individual provinces, but at the same time were responsible to the pharaoh. These officials acted as judges, tax collectors, and administrative organizers, making the law act as both a regulatory and an operational instance. Contracts, wills, purchase contracts, rental agreements, and employment agreements were fixed in writing, usually on papyrus, stone, or wood, and formed a basis for the social order. The courts of Egypt were hierarchically structured and strongly oriented towards the pharaoh and his representatives. At the bottom were local judges who settled everyday disputes, petty thefts, and conflicts between citizens. In more complex or significant cases, they were referred to higher instances, which were either directly linked to the court or regionally located. This structure allowed for the enforcement of law that was both decentralized and reflected the central authority of the pharaoh. The officials and judges were heavily involved in moral and social norms, as their judgments had to reflect Ma'at's principles. The Egyptian legal system was strongly pragmatically oriented. While the Codex Hammurabi relied on punishment, retribution, and formal regulations, Egyptian law focused on the preservation of social order. An important aspect was the regulation of land ownership and agriculture, as these formed the economic basis of society. Egypt depended on the Nile, whose annual floods made the fields fertile, and the administration had to closely monitor irrigation systems, leases, crop yields, and taxes. Conflicts over land, water, or labor were settled by law, which defined both property rights and the duties of farmers and administration. Another characteristic of Egyptian law was its social dimension. Rights and duties were strongly linked to social status. Nobility, priests, officials, artisans, peasants, and slaves had different rights, duties, and access to legal support. At the same time, the law was flexible enough to resolve disputes amicably, whether through mediation, contracts, or court decisions. This flexibility was necessary because Egyptian law was based heavily on custom and tradition rather than on fixed codes. Family and personal matters were also subject to legal regulations. Marriage, divorce, inheritance, and adoption were formalized, with written documents serving as evidence. Women in Egypt had relatively strong rights compared to other ancient cultures. They could own property, conclude contracts, and accept inheritances. This reflected both the religious idea of balance and the pragmatic need to ensure stable social structures. Religion permeated Egyptian law in all areas. Ma'at was the basis for moral behavior and legal norms. Violations of Ma'at could not only be punished socially, but were considered a disturbance of the divine order. This gave the law an ethical dimension that went beyond mere practical rules. The goal was not only punishment, but restoration of order and harmony. A judge not only had to make legally correct decisions, but also uphold the principles of justice and balance. The written tradition plays a central role in our current understanding of Egyptian law. Papyrus scrolls, temple inscriptions, and funerary texts document contracts, judgments, administrative instructions, and moral guidelines. These sources show that law in Egypt was closely linked to administration, religion, and social hierarchy. It was not an abstract system, but a living part of daily life and state organization. The Egyptian legal development influenced later cultures, especially through the combination of morality, religion, and administration. While Roman law later relied more heavily on codification and abstract principles, Egyptian sources show that law also works without complete codification, if it is embedded in administration, tradition, and religious ideas. Egypt taught that law encompasses not only rules, but values, practices, and institutions that together create a stable social fabric. This understanding of law as an integrative part of society forms an important building block for the history of law and shows how humanity has strived to ensure order, justice, and harmony since the earliest civilizations.
Chapter 5: Ancient Greece and the Emergence of Codified Law. Ancient Greece marks a decisive phase in the history of law, as it was here that principles of systematic legislation, democratic participation, and legal rationalization appeared for the first time. The political and social diversity of the Greek city-states led to different approaches to law and justice, with Athens in particular standing out as a pioneer of a codified legal system and the idea of legal equality. In this epoch, the law began to be understood no longer exclusively as an expression of divine order or administrative necessity, but as an instrument that structured and controlled human coexistence. The earliest forms of Greek law developed from the oral traditions of tribal societies. Legislation was initially highly local and flexible, tailored to the needs of small communities and closely linked to religious norms. With urbanization and the formation of polis-states such as Athens, Sparta, or Corinth, the need for binding written rules grew. The transition from oral to written laws was not only practical, but also contributed to political legitimacy. Laws were now made publicly available in order to limit the arbitrariness of the rulers and to strengthen the citizens' trust in the legal system. These developments were particularly evident in Athens. The tribulation of aristocratic families and the resulting discontent of the general population led to the first major codification under Dracon in the 7th century BC. The so-called Draconian laws were notorious for their harshness, as even minor offenses were punishable by death. However, this strictness was not only intended to deter, but also to ensure the stability and unity of the aspiring city-state. Dracon's codification was an important step as it was the first to set out the rights and duties of citizens in clear, written norms, thus taking the law out of the sole hands of the aristocracy. About half a century later, Solon carried out far-reaching reforms that sought to correct both socio-political imbalances and legal uncertainties. Solon's laws differentiated between offenses that involved public interest and those that involved private property and personal relationships. The introduction of the Helaia, a civil court in which jurors from the population took over the jurisdiction, marked a decisive change. Here it became clear that law was no longer exclusively a task of the rulers, but an instrument of collective responsibility of the citizens. Legal participation thus became a pillar of Athenian democracy and shaped the understanding of legal equality for future generations. The Greek legal system was characterized by a strict separation of private and public law. Private law regulated family, inheritance, and economic matters, while public law dealt with political, military, and social matters. This differentiation allowed for a specialization of courts and a certain rationalization of legal procedures. Courts developed into important institutions in which lawyers, judges, and citizens operated in a formalized structure. Evidence, testimony, and formal procedures were increasingly standardized so that Greek law represented an early form of systematic application of the law. Particularly noteworthy is the influence of philosophy on the development of law in Greece. Philosophers such as Socrates, Plato, and Aristotle discussed the nature of law and justice and developed theoretical concepts that went far beyond the concrete application of the law. Socrates emphasized the intrinsic obligation to justice and the moral responsibility of the individual, while Plato reflected on the ideal state and just legislation in his writings. Aristotle systematized thinking about law and state order by distinguishing between natural law and man-made law, and formulating the idea that laws should not only enforce obedience, but should reflect rationally based principles. These philosophical considerations had a lasting influence on the practice of legislation and jurisprudence and laid the foundation for later Roman law, which continued and developed the Greeks in many respects. In Sparta, on the other hand, a different form of legal culture developed, characterized by military discipline, collective duty, and strict hierarchy. Sparta's laws were strongly focused on order, obedience, and social control. The social structure required regulation of property, education, and military duties. Unlike in Athens, the political participation of citizens was severely restricted, and the judiciary primarily served the stability and cohesion of military society. These contrasting models, Athenian democracy with civil courts and philosophical reflection, and the Spartan society of order, illustrate the diversity of approaches in Greek legal history. The codification and rationalization of laws had far-reaching effects on the development of property rights, contracting law, and criminal law. In Athens, citizens were able to conclude contracts, buy and sell land, settle inheritances, and sue in court. Criminal proceedings ensure that offenses are punished and social norms are enforced. The involvement of citizens in the administration of justice contributed to the legitimacy of the laws and created a system in which the community took responsibility for upholding the law. The Greek legal development not only influenced the immediate politics of the city-states, but also had an impact far into the future. The ideas of codification, legal equality, citizen participation, and rational application of the law formed the basis for Roman law and the later European legal culture. The combination of law, morality, and philosophy in Greece shows that law not only provides practical rules, but also conveys values and shapes thinking about justice. In summary, ancient Greece shows how law was transformed from oral tradition to codified order, from aristocratic arbitrariness to civic participation, and from practical application to philosophical reflection. It is an epoch in which the law was understood for the first time as a consciously designed, rational instrument of society that was intended to ensure both order and justice. These developments mark a decisive step in the history of law and lay the foundation for the modern idea of law, and the rule of law.
Chapter 6: The Roman Empire and the Codification of Law. The Roman Empire represents one of the most formative phases in the history of the legal system, as it was here that a highly developed, systematically codified, and largely standardized legal system emerged for the first time, which became the basis for the legal cultures of Europe and beyond for centuries. In contrast to the Greek city-states, whose legal developments were strongly local and fragmentary, Rome had the advantage of an expansive political structure that necessitated uniform legislation. However, this unification of the law did not happen abruptly, but was the result of a long development that lasted from the early royal times to the extended imperial period. The earliest Roman legal norms can be found in the so-called Laws of the 12 Tables, Lex Duodecim Tabularum, of the 5th century BC. These laws were publicly displayed on 12 bronze tablets and formed the foundation of Roman law. The 12 Tables were an attempt to limit the arbitrariness of the patrician upper class that prevailed at the time by fixing the rights and duties of both the patricians and the plebeians in writing. These laws dealt with a wide variety of aspects of social life: property rights, obligations, family matters, contracts, penalties for theft and bodily harm, and rules for judicial proceedings. The publication of these laws contributed significantly to legal certainty and transparency, as every citizen could now consult the applicable standards. With the expansion of Rome beyond the Italian peninsula, the complexity of the law also grew. Roman jurists began to view law not only as a collection of regulations, but as a system that had to be logically structured and theoretically sound.
The development of the so-called ius civile as a right for Roman citizens was supplemented by the ius gentium, the law applicable to foreigners and non-citizens. This distinction was of enormous practical importance as it allowed a flexible application of the law in an empire with a wide variety of peoples, traditions, and economic structures. During the Republic, the judiciary played a central role in stabilizing the political order. Magistrates, especially the consuls and praetors, had the task of administering justice and interpreting the existing laws. The Praetorian edicts developed into a dynamic instrument that could close gaps in the existing legal system. Jurists such as Gaius or Ulpian began to write systematic commentaries that facilitated the understanding and application of the laws and increasingly rationalized the law. In this phase, a separation between legislation, administration, and jurisprudence becomes apparent for the first time, which became characteristic of Roman legal thought. Roman law saw itself not only as a set of rules, but also as an expression of justice and order. Lawyers developed principles such as equitas, equity, which made it possible to adapt the rigid law to the individual case. This was a significant advance over purely formal legal approaches, as it opened up the possibility of applying law flexibly but nevertheless consistently. The systematic analysis of contracts, property, obligations, and inheritance law led to a highly developed legal methodology that also took into account philosophical and ethical considerations. Under the emperors, especially in the time of Emperor Hadrian and the later Justinian, Roman law was further codified. The codification under Justinian in the 6th century AD, known as Corpus Juris Civilis, summarized all Roman law in a systematic form and served as a reference work for centuries. This collection consisted of 4 parts: the institutions, which served as a textbook, the digests, a collection of legal writings, the codex, which bundled the imperial laws, and the novellas, the laws added later. The Corpus Juris Civilis not only had a direct effect in the Byzantine Empire, but also had a decisive influence on the development of law in the Middle Ages and modern times, and influenced the emergence of modern civil law in Europe. The Roman legal culture was also shaped by its institutional organization. Courts were systematized, lawyers were trained, and legal education began to function as an academic discipline in its own right. This professionalization not only ensured the quality of the judiciary, but also contributed to the stability of the legal system in a huge, culturally heterogeneous empire. At the same time, the law reflected social hierarchies and power relations. Slaves, women, and non-citizens had limited rights, while patricians and wealthy citizens had more extensive privileges. Nevertheless, Roman law provided mechanisms to resolve social conflicts and maintain order throughout the empire. The influence of Roman legal principles on the later legal systems of Europe is particularly remarkable. Concepts such as property, freedom of contract, damages, wills, and the separation of private and public law still have their counterparts in modern legal systems today. The idea that laws must be systematic, logical, and comprehensible to all citizens is a direct inheritance of Roman legal development. The combination of codification, legal methodology, philosophical reflection, and institutional structure made Roman law a model that even influenced the European Renaissance and the Enlightenment. Roman law was not only a tool of political administration, but also an expression of a cultural matter of course that combined justice, order, and rationality. The ability to continuously develop law, adapt it to new circumstances, and at the same time preserve its basic principles made Roman law the most enduring and influential legal system of antiquity. The centuries-long effect shows that law is much more than regulations and punishments. It is a central basis for social stability, economic development, and political legitimacy.
Chapter 7: Medieval Law and the Development of the Judiciary. The Middle Ages were a time of profound transformations in the legal system, in which the foundations that had already been laid in antiquity were greatly changed by new social, religious, and political conditions. After the fall of the Roman Empire, a complex mixture of Roman heritage, Germanic legal customs, and ecclesiastical legal order emerged in Europe, which shaped legal practice for centuries. This epoch was characterized by a fragmentation of power relations. Cities, principalities, kingdoms, and ecclesiastical territories had their own norms and jurisdictions. At the same time, mechanisms developed to settle conflicts between different legal systems, making medieval law a multi-layered system that combined both traditional and new elements. A central component of medieval law was customary law. In many regions of Europe, the so-called people's law or moral law applied, which resulted from centuries of practice and was passed down orally. These legal forms were strongly local and reflected the way of life, social structures, and power relations within a community. While Roman law relied primarily on written codification, medieval norms were often flexible and adapted to the needs of the community. The authority of a law depended not only on formal legislation, but also on recognition by the community and the willingness of the rulers to enforce these norms. In this form, the Middle Ages combined law, morality, and social order in a way that was less pronounced in antiquity. The role of the Church was of decisive importance for the development of law in the Middle Ages. The Catholic Church had its own legal system, canon law, which influenced both church life and numerous areas of society. Church courts had jurisdiction over questions of marriage, inheritance, moral offenses, and ecclesiastical offices. Canon law was heavily codified, based on texts such as the Decretum Gratiani from the 12th century, and developed into a highly complex legal discipline. In addition to imparting religious norms, the Church helped spread a universal idea of justice that transcended local power relations. At the same time, canon law influenced secular law, as many secular rulers integrated its principles into their own legislation in order to ensure moral legitimacy and social order. Parallel to ecclesiastical law, secular law experienced an increasing professionalization. With the consolidation of royal dominions, central jurisdictions based on royal law and royal authority emerged. In France and England, for example, royal courts were established to supplement local customary law and introduce standardized procedures. Judges were increasingly trained, and writing increased as judgments and legal decisions were documented. This development led to a greater hierarchization of the legal system, as courts existed at different levels: local courts, municipal courts, royal courts, and ecclesiastical jurisdictions, each with different competences and references to each other. A significant advance in the Middle Ages was the establishment of procedural norms. Medieval procedural law developed in both the civil and criminal spheres. In civil disputes, the presentation of evidence played a central role, using oaths, witnesses, and documents. Criminal law was originally dominated by harsh corporal punishment, but the introduction of written procedures and the codification of certain rules began to make the law more systematic and fair. Also, the introduction of lawyers or legal advisors began to create a professional layer capable of handling complex legal issues and representing the interests in court. Cities and trading centers contributed significantly to the further development of the law. With the growth of trade and urban autonomy, special legal systems based on merchants, commercial contracts, and urban statutes emerged. These urban legal systems were often stricter than rural customary law and encouraged the emergence of arbitration courts and commercial courts that settled conflicts efficiently and appropriately. Especially in late medieval Europe, urban legal systems developed into important centers of legal innovation, which took up the Roman heritage again and linked it to local customs. The universities of the Middle Ages also played a decisive role in the development of law. In Bologna and Paris in particular, the study of Roman law was systematized and taught. Legal training led to a new generation of professionals who knew both Roman and canon law and applied these traditions in their respective jurisdictions. The dissemination of legal texts and commentaries led to an increasing standardization of the understanding of the law, which gradually leveled out local differences without completely eliminating regional peculiarities. Another central aspect of medieval law was the close connection between law and power. Law was understood not only as a set of rules, but also as an instrument of rule. Royal rulers, princes, and local nobles used the law to legitimize their power, resolve conflicts, and secure loyalty. This led to a dynamic balance between central and local authorities, where the enforcement of law depended on both political power and legal expertise. Despite these power entanglements, the law remained a central pillar of social stability, as it created binding norms that could channel conflicts and ensure a certain order. Medieval law was also strongly normative, with moral and ethical considerations playing a central role. The ideal of justice was closely linked to Christian ethics, which emphasized social responsibility, the observance of contracts, and the punishment of offenses. This ethical dimension gave the law authority that went beyond formal legal texts and shaped the awareness of right and duty among the population. Overall, the Middle Ages show how law arises in a complex web of tradition, religion, political power, and economic requirements. The fragmentation of jurisdictions, the establishment of customary and city laws, the professionalization of jurists, and the increasing codification of norms prepared the ground for the modern legal systems of the modern era. Medieval law is thus not only a transitional phase between antiquity and modern times, but an independent system that had a lasting influence on the foundations of European legal culture. The ability to combine different sources of law while ensuring a social order makes medieval law a central building block in the long history of legal systems, ranging from the origins of Roman codification to the development of modern nations.
Chapter 8. The Age of the Renaissance and the Revival of Law. The Renaissance was an epoch of profound social, cultural, and intellectual transformations that stretched from the 14th to the 17th century and also had a lasting influence on the legal system. During this period, there was a revival of classical jurisprudence, especially Roman law, which was now valued not only in practice but also as a theoretical instrument for the order of society. The Renaissance thus marked the transition from a medieval, highly fragmented legal system to an increasingly rationalized, codified, and centralized legal system that can be understood as the foundation of modern states. This epoch was characterized by a turn to humanism, education, and science, which also affected legal thinking. Lawyers began to see the law not only as a means of enforcing power, but as an orderly system of principles that could structure society and protect the individual. A decisive factor in the Renaissance was the rediscovery and systematic evaluation of ancient legal sources. In cities such as Bologna, Padua, and later also in Paris and Leiden, the works of Roman jurists such as Justinian, Gaius, or Ulpian were intensively studied, commented on, and taught. The students and professors of these universities analyzed the digests and institutions of Roman law not only historically, but also with regard to their practical applicability in the present. This renaissance of Roman law led to a growing standardization of legal systems in Europe, as university education created a common basis for lawyers from different regions. Roman law offered a precise and logical structure that was particularly suited to the increasingly complex urban and state legal systems, thus facilitating the transition to modern jurisprudence. At the same time, the Renaissance strongly influenced the development of secular law. In many European states, the centralization of power began through monarchies and principalities, which used the law as a means of state authority. Legislation was increasingly enacted in written form, and royal decrees or princely laws came into force, supplementing or partially superseding local customary laws. In France, for example, absolutism under Louis XIV relied on a strictly hierarchical jurisdiction that established royal law as the highest norm. In England, on the other hand, common law developed in parallel, which relied heavily on precedents, with the university education of lawyers promoting an understanding of the complex interrelationships of law. In both cases, it can be seen that the Renaissance not only represented an intellectual revival of law, but also made possible a practical transformation of institutions and processes. The Renaissance also brought with it an increasing differentiation of legal fields. In addition to civil and criminal law, areas such as commercial law, maritime law, and constitutional law developed more strongly as economic and political activities became more complex. The increase in international trade and colonial expansion required new legal norms that went beyond local jurisdictions. Commercial and maritime law were based on the specific needs of merchants and ship owners, and were often summarized in their own codifications. This specialization of law contributed to the fact that legal education and practice became more and more professional and systematic, which in turn paved the way for the development of modern jurisprudence. An essential aspect of the Renaissance was the combination of law and humanism. Humanist jurists emphasized the importance of justice, morality, and human dignity. They demanded that law should not only reflect the power of the rulers, but also ensure the protection of the rights of the individual. These ideas led to an increased reflection on the relationship between law, state, and society. The writings of jurists such as Alberico Gentili, Hugo Grotius, and Bartolus de Saxoferrato dealt intensively with the principles of just law, freedom of contract, and the legitimacy of state power. In doing so, they laid the theoretical foundations for later developments such as natural law and modern international law. The Renaissance thus showed that law is not static, but arises and develops in the interplay of theory, practice, and social needs. The Renaissance was also a time of intense codification. In various regions of Europe, comprehensive collections of laws emerged that integrated both Roman heritage and local customary law. In Italy, numerous city rights have been consolidated and laid down in writing. In Germany, the reception of Roman law began in the Holy Roman Empire, where it had an influence on practice in the form of corpus juris civilis studies. The codification aimed to create legal certainty and standardize the application of standards so that both courts and citizens had clear rules to follow. This development laid the foundation for the modern codes of the 18th and 19th century. The role of universities remained central during the Renaissance as they systematized and disseminated legal knowledge. The training of lawyers was now more theoretically sound and geared towards long-term application in a state and social context. Law faculties became centers of jurisprudence in which the principles, methods, and logic of law were taught. This contributed to an increasing professionalism that went beyond local practices and supported the emergence of a European legal tradition. Despite all the advances, law in the Renaissance was still strongly associated with power and religion. Monarchs and princes used the law to legitimize their rule, while the church continued to be an important normative and moral authority. But the Renaissance ushered in a change in which rationality, education, and systematic reflection played central roles. The revival of Roman law, the development of central jurisdictions, the codification and humanization of law created the conditions for the modern understanding of law and the development of the rule of law in Europe. In summary, it can be said that the Renaissance in law represented a phase of rediscovery, systematization, and professionalization. It combined old knowledge with new social requirements and prepared the basis for modern law, which takes into account both state order and individual rights. The Renaissance was thus not only a cultural and scientific epoch, but also a decisive turning point in the history of legal development, which transformed medieval law and paved the way for modernity.
Chapter 9. The Enlightenment and the Age of Reason in Law. The Age of Enlightenment, which stretched from the late 17th to the 18th century, marked a decisive turning point in the development of the legal system. It was characterized by a comprehensive emphasis on reason, rationality, and the idea that human knowledge and social order can be structured by logical principles. During this period, the law began to be seen no longer as an instrument of the rulers or as an ancestral tradition, but as an expression of universal principles that were supposed to promote justice, equality, and freedom. The Enlightenment thus laid the foundation for modern rule of law and influenced the emergence of codifications that were both theoretically sound and practically applicable. This epoch was characterized by a close connection between philosophy, morality, and law, and led to profound reforms that redefined the state, society, and the individual. One of the central ideas of the Enlightenment was the idea of natural law. Philosophers such as John Locke, Jean-Jacques Rousseau, Montesquieu, and Immanuel Kant formulated concepts that assumed that there were universal, unchanging principles that should govern human coexistence. Locke emphasized the rights to life, liberty, and property, while Rousseau developed the concept of the social contract, which links the legitimacy of state rule to the consent of citizens. Montesquieu, on the other hand, formulated the separation of powers as a basic principle of a regulated state in order to prevent abuse of power and to secure the freedom of the individual. Finally, Kant laid the foundation for the idea that moral action and law are inextricably linked, and that law should be based on reason and universal principles. These thoughts led to a theoretical basis on which modern constitutions, civil rights, and democratic systems were built. Parallel to the philosophical discussion, the law underwent profound changes in practice. The Enlightenment led to reforms in legislation, the judiciary, and the criminal justice system. In many European countries, medieval and arbitrary legal practices began to be questioned and replaced by rationalized, codified laws. In Prussia and Austria, for example, rulers such as Frederick the Great and Maria Theresa carried out sweeping reforms aimed at rationality, efficiency, and justice. Criminal laws were clarified, arbitrary provisions were abolished, and procedural law was systematized. The idea was that the law should be comprehensible, fair, and predictable for all citizens. These reforms not only had practical uses, but also reflected the philosophical principles of the Enlightenment, that the state should serve the well-being of its citizens and protect their rights. Another important aspect of the Enlightenment was the codification of law. The idea of writing down the law in writing and systematically now gained in importance. The codification aimed to create legal clarity and uniformity based on rational principles. In France, this led to the famous Code Civil Napoleon, which influenced not only France, but later many European countries and colonies. In Germany, among other things, the preparatory work for the general land law was created, which attempted to combine Roman law, customary law, and modern principles. These codified legal works were an expression of the Enlightenment principle that law must be understandable, logical, and accessible to all. They represented a break with traditional practice in which rest was highly regionalized, fragmented, and often difficult to access. The Enlightenment also had an impact on legal education. Universities and academies began not only to train lawyers practically, but also to impart philosophical, moral, and economic knowledge to them. Lawyers should be able not only to apply laws, but also to critically question and develop them further. This led to the professionalization of the profession and the emergence of law as an independent academic discipline. The idea was that law can only be fair if those who apply it are well-educated, rational, and ethically reflected. A decisive change also affected human rights. The Enlightenment laid the foundation for the formulation of fundamental rights to which every human being is entitled, regardless of status, origin, or religion. The Declaration of the Rights of Man and the Citizen of 1789 in France is considered a historical document that translated the Enlightenment's claim to freedom, equality, and fraternity into legal norms. These principles influenced modern constitutional development worldwide, from the American Declaration of Independence to international human rights treaties. The law was no longer seen only as an instrument of the state, but also a protective mechanism for the individual whose dignity and freedom are inviolable. The Enlightenment also influenced the reform of the criminal law. Philosophers such as Caesarea Beccaria criticized the arbitrary and cruel practice of criminal justice and called for humane, rational, and preventive justice. Beccaria's ideas led to the abolition of torture, the reform of the death penalty, and the introduction of clear, comprehensible penal norms. The criminal law of the Enlightenment aimed to prevent crimes, impose just punishments, and protect the rights of the accused. This was a decisive step towards modern constitutional states in which a monopoly on the use of force, legal clarity, and human dignity are central principles. Last but not least, the Enlightenment had an impact on the international legal order. The development of international law, commercial law, and diplomatic norms has been shaped by the idea of rational, universal principles. Hugo Grotius, although active before the classical Enlightenment, strongly influenced the period with his concept of a law of nations based on reason and justice. In the Age of Enlightenment, this idea became more important as states increasingly interacted with each other, and rules for conflict resolution, diplomacy, and war became necessary. The law was internationalized, systematized, and linked to moral principles. The Enlightenment shows that law does not exist in isolation, but is deeply rooted in philosophical, social, and political processes. The epoch was a phase of rationalization, humanization, and codification that ushered in the transition from medieval, fragmented legal practices to modern, systematic, and human rights-oriented legal systems. The ideas of the Enlightenment, which emphasized the rights of the individual, the separation of powers, codification, and rational law, still shape the basis of most modern legal systems worldwide. This epoch proved that legal development is always associated with social reflection and philosophical thinking, and that only a well-thought-out, just, and rational system is able to maintain order and freedom in a complex society.
Chapter 10. The Industrial Revolution and Modern Law. The Industrial Revolution, which began in Great Britain in the late 18th century and spread to large parts of Europe and North America in the 19th century, not only brought profound economic and social changes, but also posed new challenges for the legal system. Rapid urbanization, the emergence of new forms of production, the expansion of trade, and the increasing mobility of the population led to a large number of conflicts that the existing law could only inadequately regulate. Old feudal and agrarian legal systems reached their limits as they were geared towards a pre-industrial, largely stationary society. Industrialization demanded a flexible, uniform, and rational legal system that could protect both individual property rights and collective interests. One of the key developments was the adaptation of labor law to the new economic realities. With the expansion of factories and the growing number of industrial workers, employment relationships arose that were not sufficiently regulated in either traditional guild or agricultural law. Child labor, long working hours, a lack of safety standards, and low wages led to social tensions and provoked reform movements. In many countries, states began to set minimum legal standards to protect workers' rights. The first occupational health and safety laws, regulations on working hours, and protective measures for children were introduced. The law now began to regulate not only property and contracts, but also to take into account social justice, fairness, and human dignity. This development marked the transition to a modern, social understanding of law that combined the protection of the individual and the regulation of economic relations. At the same time, there was an increased need for contract law and commercial law. Industrialization gave rise to complex production chains, international trade relations, and large companies that needed clear regulations. The law had to define precisely how contracts could be concluded, executed, and enforced in the event of a dispute. The codification of commercial law, such as the Commercial Code in Germany or the various commercial laws in the UK, was a direct response to the economic challenges of the time. Entrepreneurs, factory owners, and traders needed legal standards that were reliable, transparent, and internationally compatible. Modern law thus developed instruments to promote economic activity, create trust, and regulate the conflict between capital and labor. The Industrial Revolution also influenced criminal law and public law. Increasing urbanization led to growing crime rates, social tensions, and new forms of crime such as theft, fraud, or violent riots in urban centers.
The police developed into a state institution designed to ensure law and order, and criminal laws were modernized to meet the demands of the new society. At the same time, administrative structures were expanded as state control, security, and infrastructure planning became necessary to organize the dynamics of industrial cities. Public law grew in importance as the state increasingly had to intervene in a regulating and protective manner in order to stabilize social and economic processes. Another important aspect was the development of property law. The Industrial Revolution led to a massive increase in private property, be it factories, machinery, land, or patents. Legal systems now had to create clear rules for the acquisition, use, and transfer of property. Patent law and industrial property rights became more important because technological innovations had to be protected in order to promote economic growth and competition. Property was no longer seen only as possession in the traditional sense, but as a central element of economic development and personal freedom. The protection of property and innovation became a cornerstone of modern law, coupled with the idea that individual effort and intellectual creativity should be rewarded. Industrialization also brought new social issues into the legal system. Questions of social justice, the labor movement, trade unions, and political participation led to an expansion of the concept of law. The law began to regulate political rights, co-determination, and democratic participation. Electoral reforms, the right to strike, and the recognition of trade unions were direct reactions to the social dynamics of industrial society. The state increasingly took on a role as an arbitrator between social groups and economic interests, whereby the law developed from a purely formal order to an instrument of social control. Parallel to the national development, industrialization contributed to the emergence of an international legal consciousness. Trade, migration, and technological innovations led to greater interconnectedness between states, which necessitated common legal standards. Treaties, trade agreements, and international conventions became increasingly necessary to regulate the growing global economic activities. Modern law thus developed not only within individual states, but also at the international level and laid the foundation for later developments in international law and international economic law. The judiciary itself underwent reforms to meet the challenges of an industrial society. Courts have been professionalized, legal procedures have been streamlined, and new instances have been created to ensure efficient adjudication. The aim was to ensure legal security, equal treatment, and rapid conflict resolution. This was necessary to maintain confidence in the legal system and to ensure economic and social stability. Modern legal institutions emerged that could reconcile both individual rights and collective interests. In summary, the Industrial Revolution profoundly transformed the legal system. It led to new areas of law such as labor law, commercial law, patent law, and social law, and brought existing areas such as criminal law, property law, and public law into a new, modern form. Law evolved from a static, locally shaped order to a dynamic, rational, and systematic instrument that could meet the complex demands of an industrialized society. Industrialization thus laid the foundation for modern law, which combines social, economic, and political aspects and protects the individual as well as the community and the state. The challenges of this period showed that law not only sets norms, but also has to react to social changes, regulate social tensions, and accompany economic development. Industrialization was thus not only an economic and technological upheaval, but also a phase of fundamental legal modernization, the effects of which can still be felt today.
Chapter 11. The Emergence of Social Law and Welfare States. The social changes that accompanied the Industrial Revolution led to increasing tensions between different social groups and made the need for state intervention clear. The harsh living and working conditions in the new industrial centers led not only to health problems, but also to social strife, which triggered political movements and social reforms. The idea that the state should bear responsibility for the well-being of its citizens developed into a central guiding principle of modern law. This consideration laid the foundation for the emergence of social law and welfare states in the 19th and early 20th centuries. In many European countries and in the United States, the first statutory social regulations were introduced with the aim of improving the living conditions of the working class. Health insurance, accident insurance, and old age provision were central elements of this new legal order. Bismarck in Germany is considered one of the early pioneers of organized social law when he introduced statutory health, accident, and pension insurance in the 1880s. These measures were aimed not only at mitigating the social consequences of industrialization, but also at ensuring political stability by providing state support to workers and thus undermining radical movements. This marked the beginning of a new era in which law no longer served exclusively to secure property and order, but also actively shaped social justice. Parallel to these developments, trade unions and workers' movements emerged that demanded not only economic but also legal recognition. The right to strike, collective agreements, and co-determination in companies became important building blocks of the new social order. Legal institutions had to create mechanisms that allowed for the negotiation of working conditions and could settle conflicts between employers and employees. This institutionalized form of social regulation showed that law was increasingly understood as an instrument of social governance that addresses collective interests rather than just protecting individual rights. The idea of the welfare state went beyond labor law to include the protection of families, education, healthcare, and social services. The law began to define access to basic living conditions as part of the state's mandate. In Great Britain, for example, comprehensive reforms were introduced in the 20th century, establishing a system of national health care, social security, and unemployment benefits. In Scandinavia, a particularly well-developed welfare state developed based on principles of universal protection, equality, and state responsibility. These reforms were not only an expression of solidarity, but also of the insight that a stable, healthy, and educated citizen state is economically and politically beneficial. Social law required extensive codification and institutionalization. Courts, administrative authorities, and special Social Security offices have been set up to examine and enforce claims. At the same time, mechanisms for financing social welfare, such as taxes, levies, and insurance contributions emerged. These legal structures made the welfare state a central pillar of modern societies and established the principle that legal protection benefits not only the individual but the entire community. Social law was thus a decisive step towards a legal system that combines social responsibility and economic stability. The emergence of social law also influenced the international perspective of law. The idea that states bear responsibility for the well-being of their citizens led to international agreements and recommendations that globally recognized labor and social standards. Organizations such as the International Labor Organization, ILO, were founded to promote minimum standards for working conditions, working hours, and occupational health and safety worldwide. These developments made it clear that law could be understood as an instrument of social justice not only nationally but also internationally, and that the principles of social law should be valid across national borders. However, the implementation of social law regulations did not meet with undivided approval. Critics saw the expansion of state responsibility as a threat to individual freedom and entrepreneurial initiative. These tensions led to legal debates about the limits of state intervention and the balance between social rights and economic freedom. Legal systems therefore had to develop increasingly flexible solutions that both guaranteed social security and enabled economic dynamism. The discussions of that time shaped the modern understanding of law as a means of balancing individual, collective, and economic interests. Another important aspect was the legal recognition of new social groups. Women, children, and minorities increasingly received legal protections that improved their rights and opportunities. Labor law, education law, and healthcare have been used as means to reduce social inequality. The law thus developed into an instrument that not only regulates conflicts, but also actively promotes social justice and equal opportunities. These principles still form the basis of modern welfare states today and are an integral part of the understanding of law in democratic societies. The emergence of social law and welfare states shows that law goes far beyond the mere regulation of conflicts. It is becoming an active instrument for shaping social developments, compensating for social inequalities, and securing political peace. The experiences of the 19th and 20th centuries have shown that the success of modern societies is closely linked to the ability to enshrine social rights in law and institutionally implement them. Social law is therefore not a part of the law, but a mirror of social values and priorities that define the modern state as a guarantor of social stability and justice. Chapter 12: The Rule of Law in the 20th Century and the Globalization of Law. The 20th century was marked by far-reaching political, social, and economic upheavals that presented the legal system with completely new challenges. The catastrophes of the two world wars, the totalitarian regimes, the world economic crisis, and decolonization led to a reassessment of the function of law and the rule of law. The idea of the rule of law, which had previously been developed within nation-state borders, now became a global principle that propagated universal values such as human rights, democracy, and equality under the law. The rule of law no longer meant only the control of state violence at home, but became a central element of the international order and a basis for the development of modern democratic societies. After the First World War, and especially after the Second World War, the international community was faced with the challenge of using the law not only to resolve conflicts, but also to prevent violence and oppression. The founding of the United Nations and the promulgation of the Universal Declaration of Human Rights in 1948 represented a milestone, as universal rights were formulated for the first time, which were to be granted to all people regardless of nationality, ethnicity, or religion. This was accompanied by the task of adapting national legal systems in such a way that these rights could be effectively protected and enforced. The 20th century was thus not only a century of national legislation, but also of the increasing interdependence of international legal norms with domestic legal systems. The concepts of democracy and the rule of law were redefined in many countries after 1945. In Europe, for example, the experience of Nazism and dictatorships in Italy, Spain, and other countries led to sweeping reforms that enshrined an independent judiciary, separation of powers, and the guarantee of fundamental rights. Fundamental rights became central elements of national constitutions, and the judiciary increasingly took on the function of controlling state power and ensuring the protection of citizens. The rule of law meant not only formal legality, but also institutionalized control by courts, the review of state decisions, and the protection of individual freedoms. Parallel to these national developments, the importance of international law grew. Institutions such as the International Court of Justice in The Hague or the European Court of Human Rights came to the fore and made it clear that law has a global dimension. The globalization of law led to a networking of legal systems in which national systems did not operate in isolation, but had to orient themselves to international norms. Commercial law, environmental law, international criminal law, and human rights became central issues of a new legal reality in which national sovereignty was increasingly tied to international standards. This development reflected that law is not only an instrument of domestic order, but also of global stability and justice. The globalization of law has also had a concrete impact on legislation and legal practice. Multinational corporations, cross-border financial markets, and global communication require new legal instruments that both protect national interests and enable international cooperation. International agreements, trade treaties, and supranational regulatory authorities emerged to create a framework for legal standards that met the complex requirements of an interconnected world. This development made it clear that the rule of law can not only be thought of nationally, but must be interpreted in a global context, in which law functions as a means of cooperation, conflict resolution, and regulation.
In the political sphere, the implementation of the rule of law has led to tensions between democratic principles and authoritarian tendencies. In numerous countries, laws were passed that restricted the rights of minorities, the opposition, and the media, often under the pretext of national security. The rule of law must therefore not only formally exist, but also be actively defended. The role of the judiciary was increasingly understood as a guardian of freedom, mediating between state power and civil rights. Courts developed new instruments to ensure compliance with the Constitution, such as abstract judicial reviews, fundamental rights actions, or international legal reviews. A particular challenge was the preservation of the rule of law in post-colonial states. During decolonization in Africa, Asia, and Latin America, new states had to establish legal structures that integrated both traditional legal forms and modern legal norms. These processes were marked by conflicts between cultural tradition, political power, and international standards. Here, the rule of law meant not only the creation of formal laws, but also the enforcement of law in often unstable and heterogeneous societies. The experiences of these countries have made it clear that the rule of law is a dynamic process that must adapt to political, social, and economic realities. Increasing globalization in the late 20th century also led to supranational legal systems in which national legislation and international norms merged. The European Union is a prominent example where jurisdiction and legislation need to be coordinated at multiple levels to ensure coherence between member states. International human rights institutions, trade organizations, and environmental agreements also showed that the rule of law is no longer just a national concept, but must be thought of globally. This development underlines the central role of law as a universal instrument that not only creates order, but also conveys values, norms, and justice. In conclusion, it can be said that the 20th century revolutionized the understanding of the rule of law. Law was no longer understood only as a tool for maintaining state order, but as a means of securing individual freedoms, regulating social and economic relations, and shaping global cooperation. The globalization of law has made it clear that national legal systems must function in an international context, and that the rule of law must now be thought of both locally and globally. The 20th century shows that law is a dynamic, adaptable system that can respond to social changes and remains indispensable as a central element of modern democracy, social justice, and international stability.
Chapter 13: Digitalization, Cyber Law, and New Challenges for the Law. With the advent of digitization and the rapid development of information technologies, the legal system changed fundamentally. While the 20th century was characterized by globalization and the creation of international legal norms, the 21st century was influenced by digital networking, artificial intelligence, big data, and virtual communication. Legal issues that previously seemed unthinkable suddenly became urgent and complex. Digitalization has changed not only the way people communicate and do business with each other, but also how state violence is exercised and controlled. Data protection, cybercrime, copyright, digital contracts, and internet regulation came to the forefront of legal discussion, and legal systems had to develop new tools to meet these challenges. Initially, the digital revolution put questions of privacy and data protection on the agenda. With the increase in collection and processing of personal data by companies and government agencies, it became clear that traditional legal instruments were often not sufficient to ensure the protection of individual rights. Comprehensive data protection laws were enacted in many countries, such as the European Union's General Data Protection Regulation, which set the standard worldwide. These laws not only regulate the collection and processing of data, but also specify how transparency and accountability must be implemented in digital processes. Data protection has thus become a central component of the modern rule of law, which is intended to ensure the balance between technological progress and individual civil liberties. At the same time, cyber law developed as an independent area of law. The increasing networking and the possibility of criminal acts in virtual space require new legislation and international cooperation. Cybercrime encompasses a wide range of offenses, from hacking, phishing, and identity theft to attacks on critical infrastructure, such as power grids, healthcare systems, and financial markets. Legal systems have had to learn to identify, prosecute, and punish these new threats. International agreements and cooperation between law enforcement agencies became increasingly necessary, as digital crimes are often cross-border and difficult to detect. The challenge was to create laws that can follow technological developments without undermining the basic principles of the rule of law and legal certainty. Digitalization also had an impact on contract law and trade. Digital platforms, online shops, and electronic contracts are calling into question conventional concepts of offer, acceptance, and contract execution. Legal systems have had to make adjustments to regulate the validity of electronic signatures, digital transactions, and virtual business processes. At the same time, new legal issues arose in the field of intellectual property, especially in copyright and patent law. Content could now be reproduced and distributed worldwide in a matter of seconds, which made it more difficult to protect intellectual achievements. The challenge was to find a balance between promoting innovation, the free flow of information, and the protection of creative works, with international agreements and supranational regulations playing a central role. A particularly dynamic field is the use of artificial intelligence and automated systems. Algorithms make decisions that were once reserved for humans, from lending to medical diagnoses to law enforcement. This raises fundamental questions. Who is responsible if an algorithm causes damage? How can the transparency of decisions be guaranteed? How are discrimination and bias prevented in automated systems? Legal systems are faced with the challenge of developing normative standards for technologies that are still in constant development. This is where concepts such as algorithmic responsibility, ethical guidelines for AI, and regulatory frameworks are emerging to ensure the protection of civil rights without blocking innovation. The globalization of law is further intensified by digitalization. Digital communication knows no borders, and a country's legislation can only have a limited impact on global digital activities. Platforms such as social networks, e-commerce marketplaces, and cloud services operate internationally, raising questions of jurisdiction, law enforcement, and harmonization of standards. International cooperation, for example, through UN initiatives, EU regulations, or bilateral agreements, is becoming increasingly crucial to create a coherent and effective digital legal system. At the same time, tensions arise between national sovereignty and global regulation, which must be constantly rebalanced. Another aspect of digitalization concerns public administration and access to justice. E-government, digital administrative services, and automated procedures make it easier for citizens to access state services and simplify the enforcement of rights. At the same time, data protection, legal certainty, and fair proceedings must be guaranteed. Digitalization can thus make the legal system more democratic, efficient, and transparent, but carries the risk of exacerbating social inequalities if digital barriers exist. Legal systems must therefore also develop strategies to ensure digital participation and protect society from technological exclusion. After all, digitalization is changing the way law is conducted. Big data and digital tools enable analyses of legal texts, case law, and legal practice on a previously unimaginable scale. Legal research can now identify trends, predict the effects of the law, and analyze decisions. At the same time, lawyers and legal systems must learn to critically question technology and set ethical guardrails. Digitalization thus not only creates new areas of law, but also changes the understanding and practice of law itself. In conclusion, the 21st century presents the legal system with challenges that are both technological and global. Data protection, cybercrime, digital contracts, artificial intelligence, and international digital cooperation are redefining the agenda of legal development.
Legal systems must respond in a flexible, adaptive, and ethical manner to ensure individual freedoms, social justice, and global stability. Digitalization shows that law is a living, dynamic system that must constantly adapt to social and technological changes in order to fulfill its central function as an instrument of order, protection, and justice.
Chapter 14. Law in the Era of Artificial Intelligence and Robotics. The increasing spread of artificial intelligence and autonomous systems poses completely new challenges for the legal system. While the law has historically been designed to regulate human action, lawyers are now faced with machines that can make decisions, learn, act, and interact without a human controlling every step. This development forces us to rethink fundamental questions of responsibility, liability, ethics, and standardization. The legal classification of AI systems, robots, and intelligent algorithms is complex, as classic categories such as perpetrator, damage, intent, and negligence often do not fit machine actors sufficiently. A central problem is the allocation of responsibility. Who is liable if an autonomous vehicle causes an accident? Is it the vendor who developed the algorithm, the user who operates the system, or the developer of the software who implemented the code? The question of responsibility becomes even more complicated as machines increasingly learn on their own and make decisions that were not explicitly intended by the original programmers. Classic liability law reaches its limits here, and new models such as product responsibility for autonomous systems or algorithmic liability are being discussed in order to create appropriate legal protection without hindering innovation. In addition to responsibility, the focus is on regulating decision-making through AI. Today, algorithms decide on loans, insurance, applications, medical diagnoses, and criminal proceedings. These decisions have far-reaching effects on people's lives. They raise questions about fairness, transparency, and discrimination. When algorithms are trained on the basis of historical data, existing social prejudices and injustices can be reproduced or even reinforced. Legal systems must therefore not only regulate, but also ensure that algorithms are verifiable, comprehensible, and fair. Concepts such as explainable AI and algorithmic transparency regulations are emerging to implement these requirements. Another aspect concerns the rights and protection of individuals in digital interaction with autonomous systems. Robots and AI systems are constantly collecting and processing data to make decisions and improve. Data protection, informational self-determination, and protection against surveillance are key challenges, especially when the systems are used in private, public, or critical areas. Legal standards must define how data may be used, stored, and shared, while ensuring that people are not disadvantaged by automated processes. This is where interfaces between data protection law, IT law, and ethics arise, which require a coordinated and dynamic understanding of the law. The social integration of robotics and AI also raises questions about autonomy, freedom, and social responsibility. AI systems not only take over tasks, but can increasingly intervene in decisions that have moral implications. Autonomous vehicles have to decide in seconds between alternatives that could endanger lives, while robots in care or social care make decisions that touch on ethical dimensions. The law must create framework conditions that make such decisions controllable and socially legitimate without restricting technological possibilities too much. Here, ethical guidelines, normative standards, and legal regulations are interlinked to achieve a balance between innovation, safety, and moral responsibility. International dimensions also play a central role. Artificial intelligence and robotics are globally developed technologies, and their effects know national borders. Different legal systems interpret responsibility, data protection, liability, and ethical standards in very different ways, which can lead to tensions and conflicts. International agreements, standardization organizations, and multilateral initiatives are becoming increasingly necessary to establish uniform standards and legally regulate cross-border applications of AI. This international perspective makes it clear that in the era of artificial intelligence, law can not only be thought of locally, but must take on global dimensions. Particular attention is paid to the regulation of autonomous weapons and military AI. Systems that can decide independently who to attack raise fundamental legal and ethical questions.
International legal norms such as international humanitarian law are faced with the task of capturing technological developments without blocking national security interests and military innovations. The debates about killer robots show how law and morality collide directly in technological practice, and how necessary binding rules are for the use of such technologies. In addition, the AI era is changing the understanding of law enforcement and justice. Automated systems can prepare legal decisions, analyze court rulings, and recognize patterns in case law. This opens up opportunities for more efficient procedures, improved legal analysis, and access to justice, but also carries risks if automated analyses are flawed or biased. The role of humans in the judiciary remains crucial, but the way in which law is applied and interpreted is increasingly shifting towards technical support through intelligent systems. These developments call for critical reflection on the relationship between man and machine in the application of the law. After all, the integration of AI and robotics into everyday life also raises economic and social questions that must be regulated by the law. Automation is changing labor markets, social security systems, and economic structures. Legal systems need to find ways to account for economic impacts, protect labor rights, uphold social justice while fostering innovation. New areas of law are emerging such as Labor Law 4.0 or digital social legislation, which seek to adapt traditional concepts to the reality of an increasingly automated society. In summary, the era of artificial intelligence and robotics is challenging the legal system in many ways. Responsibility, liability, ethics, data protection, international cooperation, and the role of humans in justice must be redefined. Law must be more flexible, adaptive, and technologically informed in order to survive in a world in which machines are increasingly independent actors. The central task remains to find a balance between technological innovation, the protection of individual rights, and social justice. The future of law will be decided in this balance, and the ability of legal systems to respond to the dynamic developments of AI and robotics will be crucial for the stability and legitimacy of the legal system in the digital age.
Chapter 15: Bioethics, Genetic Engineering, and Law. The rapid development of biotechnology, especially genetic engineering, has presented the legal system with completely new challenges that touch on both ethical and legal dimensions. Since the first experiments on the manipulation of genes, scientists, politicians, and lawyers have thought about what limits humans are allowed to cross and how society should regulate these limits. The central question that arises in the field of tension between science, ethics, and law is how to ensure the protection of people, their health, their dignity, and their environment, while at the same time not unnecessarily hindering innovation and research. Legal regulations on genetic engineering, stem cell research, genetic screening, and human reproductive technology are therefore a reflection of the social values, fears, and hopes that accompany these technologies. At the beginning of the debate on genetic engineering, the main focus was on protecting humans from risks and damage. The manipulation of genetic material, theoretically, opens up the possibility of curing hereditary diseases, making plants more resistant, or specifically promoting certain characteristics. At the same time, it entails enormous risks, as undesirable developments, unintended consequences, or uncontrolled interventions in natural systems can have far-reaching consequences. The law initially reacted cautiously by creating clear framework conditions for research projects, establishing approval procedures, and introducing ethical committees to assess the possible risks. This resulted in national and international regulations that were intended to ensure that scientific freedom and human security were reconciled. A particularly controversial topic is human germline research, in which genetic changes are made in such a way that they are heritable. The legal assessment of such interventions is difficult because they affect not only the current generation but also future generations. Many countries have therefore strictly banned germline manipulation or placed it under very strict conditions, while other nations have developed differentiated regulations that allow experimental research under controlled conditions. This area of tension shows how closely intertwined law and bioethics are. The law must make ethical concerns legally comprehensible, while ethics provides the normative framework within which legal regulations are formulated. In addition to the protection of people and health, the protection of the environment also plays a decisive role. Genetically modified organisms, GMOs, in agriculture, biotechnological processes in industry, or the release of modified microorganisms into natural ecosystems raise questions of ecological responsibility, liability, and the precautionary principle. This is where international agreements such as the Cartagena Protocol on Biosafety, which regulates the handling of GMOs, and national laws that define approval procedures, labeling requirements, and safety standards apply. The challenge is to assess the risks in a scientifically sound manner and at the same time to take appropriate account of economic and social interests. Another key issue is the issue of access to genetic information and data protection. The increasing ability to analyze an individual's entire genome opens up opportunities for personalized medicine, disease prevention, and research. At the same time, there are risks to privacy, discrimination on the basis of genetic characteristics, or the misuse of genetic data by employers, insurance companies, or government institutions. Legal systems have therefore developed data protection and informed consent regulations to ensure that individuals retain control over their genetic data and are protected from unwanted interference. This area of tension between research, medical progress, and the protection of individual rights is a central characteristic of law and bioethics. The application of genetic engineering in reproductive medicine also poses a significant challenge. Procedures such as in vitro fertilization, pre-implantation genetic diagnosis, or the use of embryonic stem cells touch on central ethical questions about the beginning of life, the dignity of the embryo, and parental freedom of choice. Legal systems must weigh up which interventions are permitted, under what conditions they are permissible, and which control mechanisms must be put in place. These regulations reflect social values and are at the same time an expression of a careful balancing of medical progress and ethical responsibility. In addition, biotechnology influences criminal law, especially in the field of forensics and genetic evidence. DNA analyses have opened up the possibility of solving crimes more precisely, identifying perpetrators without doubt, and avoiding miscarriages of justice. At the same time, questions arise about the admissibility of genetic data, the storage of DNA samples, and the protection of fundamental rights. This shows that genetic engineering is not only changing the health sector, but also the legal system as a whole by creating new means of evidence, investigative procedures, and normative requirements. At the international level, bioethics is closely linked to human rights issues. The United Nations, UNESCO, and other international organizations have developed ethical guidelines that emphasize the protection of human life, the dignity of the individual, and responsibility toward future generations. These guidelines have a direct impact on national legislation and influence political debates on the permissibility of certain biotechnological applications. The global dimensions of biotechnology show that law must not be shaped in isolation, but in dialogue with international standards and ethical principles. After all, the law in bioethics faces the challenge of remaining dynamic and adaptable. Scientific development is faster than legislative processes, and new technologies such as gene editing, CRISPR, or synthetic biology are constantly raising new questions. Legal systems must therefore act not only reactively but proactively in order to set guidelines for the responsible use of biotechnological innovations in good time. This requires interdisciplinary cooperation between lawyers, scientists, ethicists, and politicians in order to ensure a balance between research, protection of people and the environment, as well as social acceptance. In summary, genetic engineering and bioethics challenge the law in several respects. It is about the balance between innovation and security, freedom and responsibility, research and ethical legitimacy. The legal confrontation with biotechnology is an ongoing process that shows how closely law, science, and ethics are intertwined.
The task of the law is to create framework conditions that both ensure the protection of the individual and society and take advantage of the opportunities offered by technological progress. The history of law and bioethics is therefore not only a history of regulation, but also a history of dialogue between human responsibility, technological innovation, and social values.
Chapter 16, Environmental Law and Climate Protection. The development of environmental law is closely linked to humanity's growing awareness of the consequences of its actions on the natural environment. Historically, the regulation of environmental issues has initially been local and fragmentary. In the early industrial societies, as factories, mines, and cities expanded, the first regulations for the protection of water, air, and soil emerged, usually driven by acute health problems and odor nuisances. These early regulations were often reactive, limited, and heavily focused on the immediate consequences of human activities. It was only with the growing recognition that environmental degradation can have long-term global consequences that systematic and comprehensive environmental law developed, which not only minimizes dangers, but is also intended to have a preventive effect and promote sustainable development. In the second half of the 20th century, environmental awareness increased worldwide. Disasters such as the death of rivers due to chemicals, oil spills in the oceans, and the spread of smog in urban centers led to a rethink. Governments recognized that without a legal framework, long-term damage cannot be prevented, and that economic growth is not possible without taking ecological limits into account. Environmental law has therefore developed as an independent area of law, encompassing both national and international law, and operating at different levels, from municipal regulations to national laws and global agreements. A central aspect of environmental law is the protection of natural resources. Laws regulate the use of water, soil, forests, raw materials, and biodiversity in order to prevent overuse, pollution, and species extinction. At the same time, the law obliges states, companies, and citizens to use these resources sustainably. Sustainability is thus becoming a legally binding principle that is intended to reconcile economic interests with ecological responsibility. The concept of sustainability in environmental law is based on the recognition that resources are not infinitely available and that future generations have the right to an intact environment. With the global threat of climate change, environmental law has taken on a new dimension. The international community recognized that greenhouse gas emissions, deforestation, and fossil fuel consumption have not only local but planetary impacts. Agreements such as the Kyoto Protocol and the Paris Agreement oblige countries to take measures to reduce CO2 emissions, develop climate protection strategies, and report regularly on progress. These agreements show how legal systems must cooperate on a global scale to achieve common environmental goals. However, they also highlight the difficulties faced by national interests, economic development, and environmental responsibility in an area of tension that requires constant negotiations and compromises. Another important component of environmental law is liability for environmental damage. Companies, but also state actors, can be held responsible if their activities cause ecological damage. This includes oil spills, industrial pollution of water bodies, or illegal deforestation. The liability regimes are designed to ensure that those who cause damage pay for restoration and damage limitation. At the same time, they provide economic incentives to act preventively and comply with environmental standards. Legal responsibility for environmental offenses is structured under both civil and criminal law, which illustrates the range of environmental law as an instrument for enforcing ecological standards. However, environmental law is not only aimed at preventing damage, but also at promoting positive environmental impacts. Support programs for renewable energies, subsidies for sustainable agriculture, protected areas for endangered species, and measures for air pollution control are examples of the preventive and formative role of the law.
The law thus serves as an instrument for controlling social development in the sense of ecologically responsible action. Scientific findings play a central role in this because laws and regulations must be based on in-depth knowledge of ecological relationships in order to be effective and legitimate. The enforcement of environmental law is a particular challenge. Environmental problems are often complex, transborder, and have a long-term impact which limits traditional legal remedies and control mechanisms. Courts often have to assess scientific facts, oblige companies to comply with standards, and develop innovative solutions to prevent or mitigate ecological damage. This shows that environmental law is not just a static set of rules, but a dynamic, interdisciplinary area of law that combines legal, ecological, economic, and social aspects. In addition, environmental justice and social dimensions are closely linked to law. Environmental pressures often hit disadvantaged populations particularly hard, whether through air pollution in urban peripheral areas, pollution of drinking water sources, or the loss of livelihoods due to climate disasters. Legal instruments that ensure the protection of these groups and ensure the equal distribution of ecological burdens are therefore an essential part of modern environmental law. This shows the close connection between law, ethics, and politics, as environmental law not only sets technical standards but also integrates social justice and responsibility. Technological innovations, especially in the field of renewable energies, sustainable mobility, and resource-efficient production, have further changed environmental law. Legislators are responding to new technologies with adaptations, approval procedures, and incentives designed to encourage the use of environmentally friendly practices. At the same time, there is a tension between economic interests and environmental obligations, which is regulated by legal instruments such as environmental impact assessments, permitting procedures, and tax incentives. In this way, the law becomes a central steering instrument in the transformation process towards a sustainable society. In conclusion, environmental law and climate protection are closely linked in the protection of natural resources. It is a dynamic, interdisciplinary field of law that operates at the national and international levels, integrating ethical principles, taking scientific knowledge into account, and promoting social justice. The challenges of the 21st century, in particular global warming, the loss of biodiversity, and the increasing pressure on natural resources, make it clear that environmental law must not only be reactive but proactive. Legal frameworks provide guidance, set standards, and enable societies to respond appropriately to complex environmental challenges while promoting innovation and sustainable development.
Chapter 17. Business Law and Globalization. The development of business law is inextricably linked to the history of trade, markets, and economic organization. Even in early civilizations, trade and property regulations formed a central part of the legal system. In Mesopotamia, Egypt, and the Roman Empire, extensive codes existed that regulated sales contracts, obligations, trading practices, and property rights. Initially, these regulations served primarily to stabilize local markets and secure property, but they also laid the foundation for the later development of a comprehensive economic law that took on national and eventually global dimensions. With the increasing complexity of economic relations and the expansion of international trade, the need to create standardized, binding norms that are valid beyond local differences grew. Industrialization in the 18th and 19th centuries marked a decisive turning point for commercial law. With the emergence of factories, banks, insurance companies, and international trading companies, new legal questions became relevant. How can companies be organized and held liable? What rights and obligations exist between employers and employees? What regulations govern banking transactions, stock markets, and commercial contracts? It was during this phase that many of the modern principles of business law emerged, including corporate law, contract law, commercial law, and banking law. Legislators responded to the new economic realities by enacting national codes that were intended to provide both flexibility and legal certainty. At the same time, the principle that economic freedom is always associated with legal responsibility and transparency prevailed. In the 20th century, with increasing globalization, the focus of business law shifted from national regulations to international standards. International organizations such as the World Trade Organization, WTO, the United Nations, the International Chamber of Commerce, and numerous regional trade agreements create binding rules for cross-border trade, investment, competition, and intellectual property. Business law thus serves not only national stability, but also international coordination and conflict prevention between states and companies. The increasing interdependence of global markets made uniform standards and legal cooperation essential to avoid legal uncertainty, market distortions, and trade conflicts. Competition law is a central component of modern business law. Markets only function efficiently if there is fair competition, monopolies are limited, and cartels are banned. Competition rules are designed to prevent companies from dominating the market and disadvantaging consumers through unfair practices. At the same time, it aims to promote innovation by creating equal opportunities for new entrants. Globalization has made these issues more complex, as companies operate across borders and national competition laws are often difficult to apply to international corporations. International cooperation and agreements in competition law are trying to close these gaps and create uniform standards. Business law is also closely linked to financial systems and banking regulation. Financial markets form the backbone of modern economies, and their stability is crucial for overall economic development. Banking laws, securities trading regulations, insolvency law, and anti-money laundering regulations ensure that financial actors act responsibly, communicate risks transparently, and protect consumers. The financial crises of recent decades, such as the global financial crisis of 2008, have highlighted the need for a comprehensive, international legal framework that regulates both national and transnational financial markets and minimizes systemic risks. Business law thus becomes an instrument that not only regulates trade and companies, but also ensures economic stability and confidence in the markets. Globalization has also increased the importance of international trade law. Free trade agreements, customs regulations, trade conflicts, and investment protection agreements are increasingly regulated by international treaties and organizations. This shows the close interlocking of business law and diplomacy, as legal standards are often determined by political negotiations and reflect the tension between national interests, economic efficiency, and global fairness. Today, companies must comply not only with national regulations, but also with complex international standards that include contract law, labor law, environmental regulations, and tax regulations. Another central field of commercial law is labor and social law. Commercial regulations protect not only companies and markets, but also employees. Employment contracts, minimum wages, occupational health and safety, participation rights, and social security systems are regulated by law to ensure a balance between the interests of employers and employees. However, globalization has created new challenges. Multinational companies operate in different jurisdictions. Working conditions vary greatly between countries, and compliance with international standards is increasingly central to ethical and sustainable business. Economic law thus also serves as an instrument of social responsibility that ensures fair working conditions, equal treatment, and the protection of workers' rights. The enforcement of commercial law takes place at various levels, by courts, administrative authorities, international arbitration tribunals, and regulatory institutions. Companies must anticipate legal risks and implement compliance systems to comply with regulations and minimize liability risks. Law enforcement thus becomes a central component of economic activity, ensuring transparency, trust, and stability in the markets.
At the same time, new areas of law are emerging, such as digital business law, which regulates e-commerce, data protection, cryptocurrencies, and the platform economy, and illustrates the ongoing adaptation of business law to technological developments. In conclusion, it can be said that business law and globalization are closely intertwined. Business law not only regulates trade, corporate activities, and financial markets, but also contributes to the stability, fairness, and sustainability of the global economy. It is a dynamic area of law that continuously adapts to new economic, technological, and political developments. Globalization, digital markets, and international cooperation require flexible, comprehensive, and coordinated legal solutions that take into account the interests of businesses, consumers, workers, and states alike. Business law is thus not only a means of regulating economic activities, but also an instrument that combines economic development, social justice, and international cooperation to enable stable and equitable global markets.
Chapter 18. International Law and Global Cooperation. International law is one of the decisive cornerstones for the peaceful coexistence of states and for the organization of global cooperation. The first ideas of supranational norms already existed in antiquity and the Middle Ages, but systematic development only began in modern times, when states began to coordinate across borders and settle conflicts through legal norms. International law regulates relations between sovereign states, international organizations, but increasingly also between non-state actors and multinational corporations. It is an area of law that is constantly changing and must be adapted to the political, economic, and technological developments of the world. Due to the increasing interconnectedness of states and the emergence of global challenges such as environmental crises, migration, financial markets, and human rights, international law has gained unprecedented importance. Without binding rules and mechanisms for conflict resolution, international relations would be much more unstable and conflict-prone. The roots of international law can be traced back to the 17th century, when Hugo Grotius, often referred to as the father of international law, developed fundamental principles that are still valid today. He argued that while states are sovereign, they are still bound by general principles of law that have universal validity. His works laid the foundation for understanding war and peace, diplomatic relations, and the protection of neutral states in the event of conflict. These early concepts were later further developed by treaties and multilateral agreements. The Peace of Westphalia in 1648 in particular marked a decisive turning point. It established the sovereignty of states as a central norm and thus laid the basis for modern international relations and international legal systems. From then on, rules developed to resolve conflicts not only militarily but also legally, laying the foundation for the modern system of treaties, trade agreements, and international organizations. In the 19th and 20th centuries, international law gained further importance due to the emergence of global institutions. Organizations such as the League of Nations after World War I, the United Nations after World War II, and the International Judiciary developed mechanisms to secure peace, resolve legal disputes, and promote international cooperation. These institutions and their legal instruments not only define the duties and rights of states, but also act as mediators to avoid conflicts and achieve common goals. International law has become increasingly differentiated. In addition to the classic areas such as the law of war and diplomacy, new branches of law have emerged that concern trade, environmental protection, human rights, maritime law, air transport, telecommunications, and international financial systems. The continuous adaptation of the law to new geopolitical, economic, and technological developments demonstrates the dynamic nature of this area of law. A central component of international law is international law, which regulates relations between states. These include rules for diplomacy, treaties, border disputes, military conflicts, trade agreements, and much more. International legal norms are often based on international treaties, customs, and generally accepted legal principles. However, their enforcement is complicated, as international law is largely based on voluntary cooperation.
Although there are institutions such as the International Court of Justice, arbitration tribunals, or the United Nations that resolve legal disputes, their effectiveness depends heavily on the willingness of states to accept and implement judgments. This creates a special dynamic. International norms are binding, but their implementation depends on political will, power relations, and economic interests. Nevertheless, they have a stabilizing function and form the basis for the settlement of global conflicts. Human rights are another important pillar of international law. After the horrors of the Second World War, the Universal Declaration of Human Rights and numerous binding international treaties were created that protect individual fundamental rights and oblige states to respect these rights. International courts such as the European Court of Human Rights or the International Criminal Court monitor compliance with these rights and create precedents that have an impact far beyond national borders. However, the universality of human rights has also created tensions, especially when national interests, cultural differences, or political systems come into conflict with the norms of international law. Nevertheless, the protection of human rights remains an essential aspect of global cooperation and legitimizes interventions, humanitarian aid, and diplomatic measures at the international level. Globalization has posed new challenges for international law. Economic interdependencies, cross-border trade, digital markets, migration, and environmental issues require global legal norms and cooperation mechanisms. International trade agreements, environmental conventions, customs regulations, and financial regulations are key instruments to ensure stability, fairness, and sustainability at the global level. The WTO, the UN Framework Convention on Climate Change, or international tax agreements show that states are increasingly dependent on legal norms that are effective beyond national jurisdictions. Digitalization and cross-border data flows also require new regulations that ensure consumer protection, privacy, and security in the global space. A particular area of tension in international law arises between sovereignty and global responsibility. While states are formally sovereign, in an interconnected world, national decisions can have far-reaching global implications. Climate policy, pandemic control, international finance systems, and trade structures make it clear that cooperation is not optional but existential for the stability of the global community. International organizations, multilateral treaties, and binding norms try to maintain this balance by clarifying the rights and obligations of states while pursuing common goals. International law thus becomes an instrument that combines national interests, global responsibility, and the preservation of peace, security, and justice. International law is enforced through a variety of mechanisms: diplomatic negotiations, international arbitration tribunals, economic sanctions, military interventions in accordance with international legal norms, and the work of international organizations. Civil society, NGOs, and international networks are also playing an increasingly important role in monitoring compliance with standards, promoting transparency, and holding states and companies publicly accountable. International law is thus not only a formal legal construct, but a living system that is shaped by political, economic, and social dynamics and requires constant adjustments. In conclusion, international law and global cooperation are central instruments to ensure peace, stability, and justice in a complex, interconnected world. They make it possible to resolve conflicts, promote economic and social cooperation, and protect universal values such as human rights and the environment. At the same time, international law is dynamic, changeable, and always exposed to the tensions between sovereignty, power politics, and global responsibility. It is an indispensable tool for meeting the challenges of a globalized world and forms the basis for an international order based on law, cooperation, and shared responsibility. Without international law, states would be isolated, conflicts would be uncontrollable, and global challenges would be almost impossible to solve. The history and development of international law show that legal norms at the global level are essential to shape a stable, just, and peaceful world in which cooperation and shared responsibility across national borders are possible.
Chapter 19: Human Rights and International Justice. The development of human rights is closely linked to the idea of international justice, as it represents an attempt to create universal norms that govern the coexistence of individuals and communities across national borders. Human rights are an expression of a fundamental understanding of dignity, freedom, and equality that exists independently of state authority and is equally due to all people. The origins of these ideas can be traced back to ancient cultures, for example in Greek philosophy or in Roman jurisprudence, where the first concepts of universal rights and moral duties were formulated. Religious traditions such as Christianity, Islam, and Buddhism also contributed to the development of these ideas through ethical principles of justice, care for one's neighbor, and respect for human dignity. It was not until the modern era that these ideas were systematized and cast in binding norms, especially through the Enlightenment, which laid the foundation of modern human rights concepts with thinkers such as John Locke, Montesquieu, Rousseau, and Kant. They emphasize the natural rights of the individual, the inviolability of human freedom, and the need for the rule of law as a guarantor of justice. The catastrophes of the 20th century, especially the two world wars and the Holocaust, led to a profound awareness that universal norms are necessary to protect humanity from violence, oppression, and systematic injustice. This realization culminated in the Universal Declaration of Human Rights by the United Nations in 1948, which for the first time defined the rights of every individual on a global level, including the right to life, liberty, expression, education, and social security. The Declaration formed the starting point for numerous international treaties, including the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and the Conventions on the Elimination of Racial Discrimination, Gender Equality, and the Protection of Children. These treaties make human rights binding norms, the violations of which can result in sanctions and international attention. The international community recognized the need to ensure justice not only within states but also between them and toward individuals who are victims of violence or oppression. International justice plays a central role in this. Institutions such as the International Criminal Court in The Hague, the European Court of Human Rights, and various war crimes tribunals enforce norms that previously often existed only theoretically. These courts aim to hold perpetrators of serious human rights violations accountable, protect victims, and promote a culture of responsibility as a preventative measure. International criminal law is a particularly complex area, as it has to reconcile national sovereignty, political power interests, and the universal rights of the individual. Despite numerous challenges, such as the non-recognition of jurisdictions by certain states or the political instrumentalization of processes, these institutions have a significant influence on the global enforcement of justice and the strengthening of human rights. Another crucial aspect is the linking of human rights with global political and social movements. NGOs, activists, and international networks make a significant contribution to uncovering grievances, raising awareness, and exerting pressure on governments. They act as guardians of human rights, document violations, and advocate for reforms. These actors often operate in a field of tension between state authority and transnational morality, making global justice politics a dynamic, continuously negotiated field. International attention, public debates, and civil society interventions help to ensure that human rights violations do not go unnoticed and promote the emergence of new norms that respond to changing social realities. Globalization has further increased the reach and importance of human rights. Economic integration, migration, digital communication, and global environmental issues make international cooperation imperative to ensure justice at the global level. Transnational corporations, international finance institutions, and supranational organizations must increasingly be measured against human rights standards, be it with regard to fair working conditions, environmental protection, equality, or cultural rights.
The debates on corporate social responsibility, sustainable development, and social justice show that the principles of human rights have an impact far beyond national borders and increasingly involve economic and social actors. Human rights are thus not only legal norms, but also central reference points for moral action and global responsibility. However, the practice of international justice faces numerous tensions. Power politics, economic interests, geopolitical conflicts, and cultural differences often lead to conflicts between universal norms and national sovereignty. States sometimes refuse to recognize certain international judgments or selectively interpret human rights norms in line with their own interests. At the same time, new forms of justice are developing, such as restorative justice, collective reparations, truth and reconciliation commissions, and participatory decision-making processes that focus on reconciliation and social healing rather than punishment alone. These developments show that international justice is not static, but is continuously evolving to respond to historical experiences, societal expectations, and global challenges. Globalization has further increased the reach and importance of human rights. Economic integration, migration, digital communication, and global environmental issues make international cooperation imperative to ensure justice at the global level. Transnational corporations, international finance institutions, and supranational organizations must increasingly be measured against human rights standards, be it with regard to fair working conditions, environmental protection, equality, or cultural rights. The debates on corporate social responsibility, sustainable development, and social justice show that the principles of human rights have an impact far beyond national borders and increasingly involve economic and social actors. Human rights are thus not only legal norms, but also central reference points for moral action and global responsibility. However, the practice of international justice faces numerous tensions. Power politics, economic interests, geopolitical conflicts, and cultural differences often lead to conflicts between universal norms and national sovereignty. States sometimes refuse to recognize certain international judgments or selectively interpret human rights norms in line with their own interests. At the same time, new forms of justice are developing, such as restorative justice, collective reparations, truth and reconciliation commissions, and participatory decision-making processes that focus on reconciliation and social healing rather than punishment alone. These developments show that international justice is not static, but is continuously evolving to historical experiences, societal expectations, and global challenges. Human rights and international justice are closely linked because justice at the global level would hardly be possible without binding rights and protection mechanisms. They form the basis for peace, stability, and sustainable development by creating norms for the protection of the individual, providing mechanisms for conflict resolution, and opening up scope for international cooperation. At the same time, they reflect the tensions of the modern world, where national sovereignty, global responsibility, economic interests, and moral principles are in constant dialogue. The history of human rights shows that progress is often arduous and conflictual, but can be driven forward through continuous negotiation, jurisprudence, activism, and international cooperation. In conclusion, it can be stated that human rights and international justice are central elements of the global legal and normative system. They make it possible to make universal values such as freedom, equality, dignity, and protection from violence binding regardless of cultural, political, or economic differences. They promote cooperation between states, institutions, and societies, and create mechanisms for resolving conflicts peacefully. Despite the challenges that exist, including political tensions, economic inequality, and cultural differences, they provide an indispensable set of tools to ensure global responsibility, social justice, and respect for fundamental rights at the international level. The development of these norms and institutions shows that justice and human rights do not exist as abstract ideals, but must be actively shaped, defended, and further developed in order to develop their universal impact and lay the foundations for a just world order.
Chapter 20. Future of the legal system and global challenges. The future of the legal system is inextricably linked to the global developments, technological innovations, and societal changes that are shaping the world of the 21st century. While law has historically been geared towards ensuring order, justice, and stability within national borders, lawyers and legislators are now faced with a completely new dimension of challenges. Globalization, digitalization, artificial intelligence, climate change, migration, and biotechnological innovations are changing the way law is defined, applied, and enforced. Legal systems must be increasingly flexible, adaptive, and interdisciplinary in order to meet the complex requirements of an interconnected world, in which national solutions alone are often not sufficient. A central trend is the advancing digitization and automation of law. Digital technologies enable more efficient administrative processes, automated contract reviews, electronic court cases, and the analysis of large amounts of data in a legal context. At the same time, new legal issues are emerging in the areas of data protection, cybersecurity, algorithmic decision-making, and artificial intelligence. Today, algorithms make decisions that have a direct impact on people, for example in lending, application procedures, insurance, or medical diagnoses. The law faces the challenge of formulating rules that both ensure transparency, fairness, and accountability and do not hinder innovation. This requires new forms of regulation that draw on technological knowledge, ethical principles, and international standards. Climate change and the global environmental crisis represent another central field in which law is increasingly taking on a steering and preventive function. International agreements such as the Paris Agreement oblige states to reduce greenhouse gases, adapt to climate change, and promote sustainable development. National legislation must implement these goals, create incentives for renewable energies, enforce environmental protection standards, and align economic activities with ecological principles. Legal norms serve not only to regulate, but also to coordinate between different actors, to coordinate and sanction violations, and to promote innovative solutions. Law thus becomes an instrument that combines ecological responsibility and economic efficiency. Globalization is also leading to far-reaching changes in the legal system. International trade agreements, multilateral organizations, supranational courts, and global financial regulations show that law is increasingly having an impact on a cross-border level. States must not only abide by national regulations, but also respect international standards, whether in the field of human rights, environmental protection, trade, or migration. This development requires greater cooperation, harmonization of legal norms, and institutional mechanisms for conflict resolution. At the same time, tensions arise between national sovereignty and global responsibility, as international obligations often clash with local political, economic, or cultural interests. Another central aspect of the future of law is the integration of ethical and social dimensions. Technological innovations, economic development, and social progress repeatedly raise questions that go beyond the formal application of the law. Bioethics, genetic engineering, artificial intelligence, robotics, and social justice require that law not only regulates but also sets normative guidelines for responsible action. Ethics committees, interdisciplinary advisory bodies, and international standards are becoming increasingly important in order to legitimize decisions in the area of tension between freedom, responsibility, and innovation. Law thus becomes a dynamic instrument that combines normative principles, scientific findings, and social expectations. Migration and global population shifts pose additional challenges for legal systems. Law must not only secure the rights of migrants, refugees, and international communities, but also keep social, economic, and political structures stable. International agreements, asylum laws, integration programs, and human rights standards are part of a complex system designed to ensure justice, security, and social cohesion.
At the same time, tensions arise as resources, social systems, and political institutions come under pressure. Here, law functions both as an instrument of protection for individuals and as a framework for social compensation mechanisms and political stability. Another trend concerns the merging of national and international legal systems. Supranational institutions such as the European Union, international trade organizations, and multilateral courts show that law must increasingly be coordinated at several levels. Nation-states must adapt their legislation to international norms, while international actors monitor compliance and implementation. This development increases the complexity of the law, but also creates new opportunities for global cooperation, conflict resolution, and regulation in an interconnected world. Law is becoming a manner of reconciling national interests, international standards, and global responsibility. Another central aspect of the future of law is the integration of ethical and social dimensions. Technological innovations, economic development, and social progress repeatedly raise questions that go beyond the formal application of the law. Bioethics, genetic engineering, artificial intelligence, robotics, and social justice require that law not only regulates but also sets normative guidelines for responsible action. Ethics committees, interdisciplinary advisory bodies, and international standards are becoming increasingly important in order to legitimize decisions in the area of tension between freedom, responsibility, and innovation. Law thus becomes a dynamic instrument that combines normative principles, scientific findings, and social expectations. Migration and global population shifts pose additional challenges for legal systems. Law must not only secure the rights of migrants, refugees, and international communities, but also keep social, economic, and political structures stable. International agreements, asylum laws, integration programs, and human rights standards are part of a complex system designed to ensure justice, security, and social cohesion. At the same time, tensions arise as resources, social systems, and political institutions come under pressure. Here, law functions both as an instrument of protection for individuals and as a framework for social compensation mechanisms and political stability. Another trend concerns the merging of national and international legal systems. Supranational institutions such as the European Union, international trade organizations, and multilateral courts show that law must increasingly be coordinated at several levels. Nation-states must adapt their legislation to international norms, while international actors monitor compliance and implementation. This development increases the complexity of the law, but also creates new opportunities for global cooperation, conflict resolution, and regulation in an interconnected world. Law thus becomes a means of reconciling national interests, international standards, and global responsibility. Finally, the future of law is also changing the role of lawyers and legal experts. The requirements for legal knowledge are expanding to include technological, economic, ethical, and global dimensions. Lawyers must be able to analyze complex relationships, develop interdisciplinary solutions, and adapt law to dynamic social and technological changes. Legal education is increasingly geared towards this complexity with interdisciplinary courses of study, digital competence, and international networking. This will make the application of the law more flexible, more well-founded, and better prepared for the challenges of a globalized, digital, and technological world. In conclusion, it can be said that the future of the legal system is characterized by dynamics, complexity, and interdisciplinary requirements. Digitalization, artificial intelligence, climate change, globalization, migration, and technological innovations are changing the framework conditions under which law operates. Legal systems must be flexible, adaptive, and normatively sound to ensure order, justice, and stability in an increasingly interconnected world. They must integrate ethical, social, and ecological aspects, promote international cooperation, and at the same time take national interests into account. The challenge is to create legal norms that are flexible enough to respond to new developments and at the same time binding enough to ensure safety, justice, and protection. The future of law is thus an ongoing process of learning, adapting, and shaping that reflects the values, expectations, and responsibilities of society in a globalized world.